So tune in, get your questions going. Feel free to tweet them at Paul Gorden or use the hashtag SMDayADL or tweet them to at SMDayADL.
All right. Well, thanks everyone who's maybe able to come in, and thanks everyone who's logging in to watch this. It's kind of under pressure now for being filmed in 2 different ways. So hopefully it'll come through. Feel free to shout out questions as I go through or to send them through on Twitter. Also, I might have to jump through a couple of things quite quickly because this is a longer presentation that I've cut down for today. So apologies if I go quickly. If you want to ask questions afterwards, we'll have a more extended session, or if you want to tweet me something, feel free. But I'll stop using my time up explaining why I don't have much time, and we'll get on to the actual presentation. So today I'm going to be talking about basically top tips for social media law. And I'm wondering if this is all going to be backwards on the Google Hangout. That's going to be hilarious. So everyone on Google Hangout, grab a mirror, hold up your screen, and that way you can be able to see what's on the screen. In any case, I'm going to be covering a few things, looking at what you can and can't say on social media, mainly defamation in a social media context, misleading and deceptive conduct in social media, and if we have time, some tips for giving advice online. Before I start though, I always like with these presentations to go through why we should be concerned about social media law. And the reason behind it is, I've described it as the amplification social media really does provide. So back in the day, if I were to say something to someone around this table here, it might go 1 or 2 people further, but chances are I wouldn't be broadcast around the world. But these days, you put out 1 tweet, suddenly 3 people are going to retweet that, and then 3 of their contacts retweet that, and all of a sudden you have a flock of tweets flying around the world faster than you would otherwise imagine. And because of that, the impact of what is said online from a legal perspective has a much greater gravity. And we'll see that in a couple of cases that actually had judges saying social media does have a different place to other forms of media because of the amplificatory nature of it. And you only need to look at the recent issues that we've had a few months ago now with the Florio milk companies. Everyone familiar with the joys of the anti-halal brigade and their actions with Florio milk? Mm-hmm. So that's a good example of how a form of protest, a form of complaint that would otherwise not have had any airtime at all, suddenly was able to get a company to pull out of a $50,000 contract, which they subsequently re-entered. But in any event, that would have done massive damage to the brand there. And it's all because of the social media and its amplificatory nature. So with social media, we have the power in the hands of the people. The public has the ability to shape and influence the conversation in the way they never had before social media, which means mistakes are amplified and positive perceptions are won or lost. So let's look at defamation. That's often what comes up in these contexts. I have to say, in the past probably 9 months, I've had more defamation queries than I have in my preceding 6 years of practice. It's really coming up, and almost all of them relate to online defamation, generally through social media. Great man Winston Churchill once said that a lie gets all around the world before the truth has a chance to put its pants on. I just like that quote, it was right. But basically, people are more and more concerned about social media because instead of something just being fleeting, it is now both widespread and also it is permanent. So that is it for everyone. That's okay. Okay. So we're just talking about defamation. So defamation is any statement which is made that would have the impact of harming someone's reputation. There are also defences to defamation, things like fair comment, truth, honest opinion, qualified privilege. So I'm not going to bore everyone here with going through what those things are. But basically, if there is a statement, let's assume statements are defamatory and they're made online, they have an impact. And the reason why I think that this growth in defamation is happening is that people think that what they're posting is anonymous. People are keyboard warriors behind their computer screens and they think that what they're saying can be said with impunity. But recent decisions have shown that might not be the case. As far back as 2013, we had the case of Shane Radbone, who was a sports personality. And he was able to take Google School to find out the names of bloggers who were posting unkind things about him online on blogger platforms. I'm sure everyone's familiar with the Dallas Buyers Club case. That was a case of what's called pre-action discovery, where the Dallas Buyers Club LLC said, look, we don't know who's been pirating our movies, but the ISPs do. So at least they can provide us with the account holders who line up with these IP addresses, and they were able to a court process to find out the identity of who those people were. So that brings me to my first top tip, which is that social media is not as anonymous as people think. That has important connotations for businesses and individuals. Firstly, if your business or the brand that you're supporting have been defamed, there is a way that you can find out who did it. I'm not saying it's an easy way or a cheap way, but there is a way to find out who's done it. It also means that employees need to be very aware of the fact that what they're saying can be brought back to their employer, and that might have consequences in terms of their employment. It also might have consequences in terms of how the business disciplines them if they say things which are inappropriate. I'll get to that in some more detail later through that context. Transition. We saw this quite strongly in a case called Nickel and Farley. That was a case involving a school student. His father, from my understanding, was a music teacher and had been let go, whilst another music teacher was given a hall named after her and along the contract and all of his honours. He was upset, and so he posted some defamatory comments on Twitter. And the reason why this case is a really good one to look at is it's fascinating to me to see how the courts actually concluded it. What the judge said was that when defamatory publications, I probably won't read out everything on the screen, when defamatory publications are made on social media, it's common knowledge that they spread. They're spread easily by the manipulation of mobile phones and computers. Their evil lies in the grapevine effect that stems from the use of this type of communication. Taking that into account in the effect and advantages. So other than having an awesome grapevine pun in the judgment, this was a clear and probably, I'd say, the first demonstration of the court really taking that kind of notice of how insidious social media can be in propagating messages. And if this guy had said it to some friends, if he just sent an email, that wouldn't have had the same level of impact or damage that a comment made on social media has. And that's an important part of educating people. An important part of educating employees. It's also an important part of educating the general public in having your house rules very clear to your social media site. Saying, look, you should be aware that what you say on here is different to what you say to your friends in the street. And it can have significant consequences if things go wrong. And that's the reason why we moderate our posts. That's the reason why we might take something down or ask you to remove something if you said it on our social media site. And that's top tip number 2. The courts have now grasped the amplification effect. Once things are up online, though, it is quite hard to get them down. I'm not sure if anyone saw in the papers last week, but an academic whose name escapes me, but has started to sue Google in the Supreme Court of South Australia for having search listings to defamatory content. Now, she's already had the defamatory content taken down, but there remain search listings on Google which have negative connotations about her. I actually have a court case at the moment that is in very early stages with a client with exactly the same issue. It's happening more and more. And the interesting thing is, I was talking to a defamation lawyer or IP lawyer in Sydney the other day, and she was saying she was very surprised by it. Because if you report copyright infringement to Google, they take things down like that. But if it's defamatory, it's much harder. And if you want to actually get the search results from Google, it's near impossible. Google are actually fighting this case hard, which is in stark contrast to the pre-action discovery case I mentioned before with Shane Radbone. In that case, they didn't even show up to court, whereas in this case, they are fighting with self-represented litigants. So she's there without any lawyers, she's fighting this as hard as she can. And Google are standing up to her because they don't want to have to pull search lists. So if you're brand or if the person you know has been the same, it's really not just the content itself. It's those search results that can be just as damaging when people do Google searches for them. And getting it taken down is increasingly more difficult. And that's object number 3. Once content's out there, it is never easy to get it taken down. To my knowledge, the only way that you'll be able to get Google to take down a search result is if you have a court order saying that they have to. That's a very time-consuming and expensive way of dealing with content. So, moving on from defamation, the other thing that you need to be aware of on social media is the impact of claims that have been made. A business is responsible not only for the things that it says on its official channels on social media, but it is also responsible for what is said by its employees, staff, and what is said by third parties. And that's really the hard one. Suddenly we're in a world where what Joe Boggs down the street says about my brand can be brought back to me, the company about who's speaking. There's a case called Algae Pathways where a company was held to have breached undertakings given to the court and provisions of the Competition and Consumer Act when third parties made posts on their Facebook and Twitter accounts saying that their services cured nut allergies and cured a variety of skin conditions when there was no scientific basis for those things instead. Even though those comments were made by third parties, the court held that the company was responsible because they had the ability to moderate that content. Not so much with Twitter, but certainly on their Facebook page, they could take those posts down, they could post corrected statements, and they didn't do so. We've seen similar statements being made by the ACCC and the Advertising Standards Board in relation to Smirnoff vodka. Smirnoff was taking the Advertising Standards Board over posts on their Facebook page which were alleged to imply that drinking their products improved your sexual prowess. I don't agree with those highly anything, but it was found that they didn't actually breach the standards. But the comment was made by the Advertising Standards Board that had they breached the standards, Smirnoff would have been responsible. The ACCC came out afterwards and released a statement saying, "Yes, we agree. The statements can be moderated, and they aren't. And a reasonable period of time has passed in which the company could have or should have acted, then they will be responsible for that content." Well, I had a task tip there, but apparently I don't. My tip is to monitor what happens, have a good policy in place, and make sure that you take reasonable steps when things are said that you know to be misleading or deceptive or in breach of some kind of standard.
You've got a question.
Oh, yes.
Can a brand sue fans with false claims about the brands on social media?
Theoretically, yes. If I have a brand and I am, someone says something about my brand which is false, misleading, deceptive, I can certainly take action against that person, although it's harder to take action against the individual because you need to show that it was in trade or commerce that they made using the deceptive conduct provision. So the short answer is yes, but it's complicated. Another one? Okay. Just in light of the time, I think we're almost done. Okay, 5 minutes. I'll deal very quickly with owning content online. So who owns posts on social media? Well, it depends. Generally, the terms and conditions in most social media sites, such as Facebook, Instagram, Twitter, Pinterest, say that you still own your content when you post things up on there, but you grant them a license. And that license is a very broad one. Generally, it's a license to reuse it, to sub-license it, to do whatever they want with it, including commercially using it. And that can be pretty much equivalent to them owning it, because you lose a lot of your rights to use that content, or at least you've got the right to prevent other people from using that content when you give that people a license. The other thing to consider is the fact that once you post something online and it's been retweeted, reposted, and reshared, then it is duplicated on a lot of other people's sites, and you may lose control of it that way. You may be able to pull it back from what you've got on there, but obviously if other people have posted it, you can't pull it down from it as well. And part of your license that you give to the various social media sites allows for that to happen. Also, employee content is generally going to be owned by the company, so if you're posting on behalf of the brand, they might own it if you're working for them. If, however, you're a contractor, so let's say you're running a digital agency and you post stuff on behalf of the brand, there is a question as to whether or not they would own it or you would own it and grant them the license to use that content. The answer to that question will vary in each case and will depend upon the contract that you have in place. Also, third-party content comes on your social media page is probably not yours, but you do probably have an implied right to use it because it's imposed. So, top tip number 4, on slide, a license may be as good as ownership, so be aware of what you're doing when you're putting things on your own. Now, I've got a whole bunch of other stuff about employers and employees and things like that, but let's probably stop there. See if anyone has any questions.
With the Google case, why are they arguing so strongly to keep the search listing?
My feeling is that they're concerned that it would open up the floodgates. In the European Union, they've already got a decision which says that they have to allow people the right to be forgotten. So if you're in Europe and you don't want to be listed on Google anymore, you can follow an administrative process and have yourself removed. I think they're concerned that it would be opening the floodgates to similar types of actions here in Australia where they feel allowed to be taken off. Which I have to say, when I first got this case from this one guy that I'm dealing with at the moment, I was under the impression it would be quite simple. You send an email to the Google removal page, things like that, saying, yep, fair enough, take it down. Not the case. We actually provided them with court orders and they said, no, we don't think those court orders are good enough. So they've been incredibly difficult to deal with in that respect. And they're just probably protecting themselves in that respect. But it is a very challenging situation. And I've got this guy who's had very nice things to say about him. He's impacting his life. And he's now being forced to take action because they refuse to take it down. It's very difficult.
Going back to your first tip, would you recommend any company, I guess of any size, more so smaller companies that do anything on social media, to have a set social media policy and guidelines, obviously for the person who's managing that, but their employees as well?
I think that if it's more than one person dealing with social media, then there should be a policy in place. And that policy doesn't have to be long, be a page, to basically outlining for them, okay, what happens to stuff posted online, who's in charge of social media triage. That's really where it comes into it. Who's monitoring them? How often are we monitoring them? What do we do with phones on there that we're not familiar with, we're not comfortable with? Just outlining those basic steps that you should be taking and having that in a written document goes a long way. Particularly if you were ever in court, and you're able to say, look, yes, this content was there, but look, we have a policy in place, we were following the policy, and we've taken reasonable steps, then the amount of damages you might be facing will probably be reduced. Was there any other questions? Well, thank you very much, everyone, for coming. I hope that was of some interest. If anyone wants to get in touch, at Paul Gorden on Twitter.